more specifically in your local administration environment. But first, some preliminaries. We are going to record the training. You might have just seen it pop up today. And then that way that you can refer back to it later, or we'll make it available, or share with some of your colleagues that might not have been able to attend today. We do ask that you mute your microphones during the presentation if you're not speaking. We also encourage you to use the raise hand function if you have a question at any time. We will try and address the questions today, but if not, we will make sure that we get back to you to answer those questions. I wanted to say, give a big thanks to other staff members, Matt Weber and Shauna Hooks, and our IT and CI team, Christina Miller, who's going to be participating from the project staff. Julie Barnowski is going to present from finance. We had a lot of assistance from Barb and Tay Smith and Scott Sugarman, and then also Matt Westerman in legal. So thank you, and without further ado, we'll try to move this along. Our team today is going to, and I guess I have to pause for a second. Matt, I'm having some technical troubles getting the move. So our team today is going to take you through kind of just this introduction, and then we'll move, much like we addressed liens in our organization, it's a team effort. So we're going to show you some of the legal overview of the public lien requirements, and then we're going to move into the fiscal operations and what requirements are in the fiscal, and then we're going to finish taking you through the OFCC lien process and how to work with that, and then we'll address any questions you might have. So without further ado, I'll turn it over to my colleague, Matt Westerman, to start us off. Matt?
Good morning, everyone. My name is Matt Westerman. I am a senior legal counsel with the commission, and I've been unfortunately or fortunately dealing with liens for over 20 years now. It's one of the first things that we're going to discuss today is
hey, Matt, can you hold on one second? I need to, Matt Weber, can you get us back on the actual slideshow? Welcome to teleworking. I don't know who's control. Go ahead, Matt.
Okay. As John said, I'm going to try to give you a legal overview. It's just going to touch the surface of some of the issues you may encounter from a legal perspective with liens. Both John and I have sat through legal education courses that lasted 3 hours discussing this subject. So we're going to attempt to give you a brief overview in the next 10 minutes of what you need to know with regard to administering a lien. What exactly is a public lien? A public lien is a definition of claim of funds that are due and unpaid to the principal contractor, the CMR, DB, or general contractor, or if you're still doing a project that's multiple prime, it'd be every one of the prime contractors would be someone that a subcontractor, material supply, or labor would file a lien against for non-payment. Public lien is dramatically different from the private sector, where a contractor can actually lien the property. Public liens are addressed in the Ohio Revised Code sections 131125 through 131132. 1311 addresses liens both private and public. That's 131125 deals with the public liens. It's important to know that one of the things with liens, I'll just give you a brief history before we move on. The concept of lien was introduced into the United States early on. Thomas Jefferson introduced legislation in the Maryland General Assembly in 1791 in order to introduce the concept of mechanics liens into law here in our country. And the underlying purpose at that time was to get laborers to perform work in Washington, D.C., which was then a part of Maryland, in order to facilitate construction. The term mechanic at that time is not typically what we refer to mechanic. It's somebody that simply worked with their hands with laborers or construction workers. So that's a little background before we move on.
Thanks, Matt. So for the next get it here. So for the first kind of main item that the public owner is going to have to do on a project is a notice of commencement. And that's set forth at revised code section 1311.252. And what that does is really it's telling it's telling the world, so to speak, that we have this public project and who are the players involved. So it tells the subcontractors and suppliers, it gives them information about the project, and perhaps more importantly, it tells them who at the public owner that they should provide their notice to if there's a circumstance when they aren't getting paid and that they feel that they should they want to request the public lien or an affidavit of claim. Just to let you know, there is no real impact to any claimants if the public owner does not issue the notice of commencement, as they'll still be protected. It might alter some of the timelines that they're addressing, and we might that we're going to talk about later. But it is an important feature. At OFCC, we have our project coordinators ultimately issue the notice of commencement.
The filing of the lien or the affidavit of claim is what initiates the public lien process. It's discussed in Revised Code section 1311.26. It sets forth the requirements that a lien claimant, whether it be a material supplier, a laborer, or a subcontractor, must put into their affidavit in order to perfect their affidavit of claim or lien. It's important to note that the general most contractors are still going to refer to it as a lien. The only time that you'll actually have it discussed in an affidavit of claim is probably when you're discussing it with opposing counsel or counsel for a contractor. Again, the contents, you must have the project number, name, the amount due and unpaid for the labor performed or materials furnished, the last date when labor work was performed or the materials were furnished, and the principal contractor or subcontractor party against which the claim affidavit is being filed in this document must be notarized. Generally speaking, we'll interpret this form rather broadly when we receive what's perceived as an affidavit of claim. What you'll see a lot of times, some people will include the complete legal description for the property. This is tied in more to an actual mechanics lien than it is an affidavit of claim, but we get liens all the time that have this type of information attached. It's not necessary as long as they have the project number. We've had various times where we've had to help identify some of these issues, but we have a tendency to interpret it broadly, and if there's any issues with the form that's submitted, that can be raised by the principal contractor. Again, if an individual laborer files a claim on a project, which we've had happen a few times, the form of the affidavit they submit can be fairly non-compliant, but we still have a tendency to interpret broadly.
The next, just to make you aware of, this is not something that will impact necessarily you as a public agency or owner, except for evaluating the lien, but the claimant must serve the affidavit on the public authority within 120 days of performing the last labor or work furnished. It typically hasn't been, in our experience, too much of an issue, although we most recently had a case where it is an issue on a piece of litigation that was filed. In addition, the contractors may can require the recording, of a public lien, and what they need to do is file it in the county recorder's office where the project is located. What that does is gives that contractor or claimant a preference over other lien claimants who did not file with the county recorder. So in the case of multiple affidavits of claims on a project, the statutes call for a pro rata distribution of any remaining funds. Now, hopefully, in your experience when you're dealing with it, if you have a lien that you're only going to get perhaps maybe one lien at a time, a circumstance where there's a battle between the prime contractor and a sub over maybe scope, and oftentimes when there's a disagreement before a claim is issued, you might see that the contractor or the sub or the material person submits a lien for an amount and there's a dispute. If you start to see multiple liens on a project, that really is a sign, and some others might talk about it, that there might be other things going on. And one of the cases where we haven't had too many, but on the projects where we've had a large number of liens on one project, that's usually a sign of financial distress for the prime contractor. And they might be working on several projects and as we state, kind of robbing Peter to pay Paul. And it might be a sign that you get to see from if you're noticing performance and timing slip, or you start to hear rumblings through the project meetings or on the work site of contractors talking about not getting paid timely before they actually file a lien. So it gives you a hint of how projects might be going. But hopefully, and the multiple lien scenario does not occur too often, but every once in a while we have to address it, and we just want you to recognize that it might be a sign of bigger problems.
The notice of furnishing is covered under the code as well under 1311-261. It's a requirement for a remote subcontractor, lower tier subcontractor, material supplier that doesn't have a direct contract with the prime contractor to perfect the lien. Once again, this applies to all delivery methods. Must be served on the contractor within 21 days of the first work or material provided. If you don't do within 21 days of furnishing the work or materials, and you may not be able to perfect the entire amount of the lien. Late notification is okay, but as I said, it impacts a potential amount. There is no requirement for laborers not to file a notice of furnishing. The important thing about this is this does not necessarily impact how the public authority, public owner goes about doing their business with regard to addressing liens. Sometimes we will get served with copies of notice of furnishings, even though we're not required statutorily to be served with those. We simply serve that as transitory. We can don't necessarily have to save those as part of our file for the lien, etc. The notice of furnishing does have a requirement that the prime contractor and the subcontractors have to provide notice to the lower tier subs who the public authority is and their address, as well as if you're farther down, who the prime contractor is and their address, which may impact rights but doesn't actually impact the public owner rights.
So after the claimant provides the public authority their affidavit of claim, we use the term lien all the time. There are obligations for the public owner, and this is when it really kicks in. And those obligations are that the public authority needs to notify the prime contractor and surety within 5 days of receipt of the public lien. And those 5 days, it's when it comes to the person notified on the notice of commencement. They also must advise the principal contractor that it has 20 days to dispute the lien. The impact if it doesn't dispute in time is that it ascends to the appropriateness of the lien. The public owner also has the obligation to detain funds when they become due and payable, up to the balance of the remaining balance of the contract. And that's an important point, is that our liability, the state's liability, is only at the maximum the amount of the remaining funds under the contract. So any funds retained should not exceed the balance that's due under our contract. And then the funds are not escrowed until they become due and payable to the contractor. And that's kind of as a practical application, because we're trying to make sure that we're protecting the appropriation. And it also allows some time for the contractor and subcontractor, or the claimant, to resolve the issues before we actually have to start the kind of process that we do. And as you will see throughout the presentation, even though there's the lien requirements are kind of very prescriptive, and they also require some work on the behalf of the public authority. The principal concept is that it has to dispute the claim within 20 days of notice from the public authority. As we talked about, if the contractor does not dispute it within 20 days, then it effectively assents to the correctness of the lien. And then if that doesn't happen, then we're required to pay it to the claimant. The public contractor can also bond off the claim, which is in Revised Code section 1311.311. The bond needs public authority approval. So at this point, we would ask that you would want to work, as we do in our OFCC, work with legal counsel and the team to review the bond. And the bond must also be for 1.5 times the amount of the lien claim. And then the principal contractor also can issue a notice to commence suit, and we're going to talk about that shortly.
The notice to commence suit is something that impacts what we do as the public authority or the owner, but it's once again it more governs a relationship between the other parties. The public authority, principal contractor, or subcontractor that receives a lien may serve notice to commence suit, and it simply requires that the lien claimant file a lawsuit to enforce their rights within 60 days, or the lien becomes void. The affidavit of service of that notice should be filed with the county recorder within 30 days of the notice being served. And if the lien holder does not commence suit, once again, the lien is void. I don't think I've ever checked to see if the affidavit of service was filed with the county recorder. Once again, that's something that's going to be part of litigation should it ensue between the principal contractor and the subcontractor filing the lien. It's important to note that we would never, as a public owner, I'd say never, but we would not issue a notice to commence suit because of the cost associated with the notice to commence suit. If we have a lower tier subcontractor with a $10,000 claim, we ask them to initiate litigation. We're going to spend more money filing a lawsuit than they have in the actual claim. So we are hesitant to use our authority under the statute to issue a notice to commence suit. The next item up is the escrow requirement. We've touched on this a little bit earlier in the presentation, but 1311.28 of the revised code provides the requirement that we place the lien funds or the retained funds into escrow. And this is provided for under section 153.63 of the revised code, which provides that the contractor must be paid the amount due or have the funds placed in the escrow account by the public owner. And in order to do so, you must have an escrow agreement with the bank. Once the funds are placed in an escrow, they can only be released by court order, agreement of the parties, or in situations where somebody has not initiated litigation pursuant to a notice to commence suit and the lien has been declared void. Other requirements with regard to escrow: the escrow agreement agent shall be compensated for its services as agreed to in our escrow agreement and from the income from the escrow account. So basically any interest earned on the money that's placed to the escrow account will be used to help pay the fees associated with the escrow account. In today's day and age, a lot of times what we find is that the amount of the fees are equal to or sometimes can actually exceed the that is earned off the escrow account. And that's what makes this next piece so important, this next bullet point. The agreement may include several provisions. Some of them are set forth in the statute, but not limited to granting authority for the escrow agent to commingle the escrowed funds with funds being held pursuant to other escrow agreements. And in that case, obviously, if you had a project where you have multiple liens, you don't want to set up an individual escrow agreement unless you have to for funds. All the funds can be placed into one escrow agreement, which is our practice. And we leave it to the escrow agent to accurately track the interest related to those funds. And of course, the escrow agent is going to limit their liability as part of this agreement. If the big point to understand, if the money is not paid or deposited into the account, the governmental entity shall pay the contractor an amount equal to 8% annual interest compounded daily. So it could be for a large lien, the amount being held, it could be a pretty significant penalty if you don't put it into escrow as required by the statute. So generally speaking, just some escrow best practices. If you're familiar with our documents, there are additional reasons that you can withhold funds, including defective work, liquidated damages, failure by the contractor to provide a schedule, etc. So obviously, consult with your legal counsel to determine whether these funds should be placed into escrow. I know I've been involved with several disputes that were on either in litigation or on tract of litigation where we had withheld funds for various reasons. And if you think that you're going to be holding them for a period of time, it might be good to put them into escrow. So at least you're accruing interest should the resolution of the dispute not necessarily go in your favor. There are additional guides out there with regard to escrow. When you can look at the 2016 OFCC Management Guide for Capital Improvement Projects for more information on escrow and liens. We also have our OFCC website, which has standard forms and agreements and standard requirements. It should be noted these same requirements will apply to the escrow required for retainage account is set up pursuant to revised code 153.63 as well. Obviously, before setting up an escrow account, please consult with your legal counsel, OBM and state accounting, and make sure that you enter into a proper escrow agreement. And it does require you to enter with a bank or other permitted financial institution. At this time, we can entertain questions, or as John said, we can also take questions via email to John or I if you have specific questions. So I didn't know if anybody had any questions at this time.
Well, if not, feel free to continue to put them in the chat if you want. At this point, I think, Julie, you're going to take over, right?
Yes, I am. Okay, just 1 second while we transition control here. Okay. Sorry, I'm not seeing, there we go. I'm not seeing the control to move on to the next slide. Matt Weber, I don't know if you need to do it for me, but
it's set up so I think you can just left click now at this point.
Okay, great.
To go forward. So
there we go. Okay. Sorry about the technical difficulties there. Good morning. My name is Julie Barnofsky, if we've not met before, and I work in the finance office at OFCC. At this time, I'm just going to give you a brief overview of how your finance office should be involved in the lien process. There we go. There's quite a delay. Matt, can we go back to the previous slide? Matt Weber.
yeah, is that not the previous one?
There we go. Okay. There's a delay in the slides, so I apologize. Okay. All right. Now, hopefully we're going to move forward here. The first thing you're going to need to do as an agency is to open a savings or an investment bank account to hold the monies that are required to place in escrow during the life of the lien. You'll want to contact OBM, State Accounting, regarding the establishment of this type of account. Another thing to keep in mind is that when the state auditors review your financial processes, they're going to want to see a monthly statement from the escrow bank, as well as a reconciliation of that account. And finally, every year, your finance office is required to file a report with OBM called a gap report, and your escrow account will need to be listed on that gap report. This next slide details notifications that need to be sent to all the parties involved in a lien. OFCC has one person in our finance office, myself, who has taken the lead on issuing communications and recording the liens and escrow transactions in OFCC. We believe that it's important to have one individual act as the hub for all communications, because this will keep the process streamlined and hopefully ensure nothing is missed. However, I do want to stress that I work closely with our legal office, with Matt and John, throughout an entire lien process. So if you have any questions whatsoever, I encourage you to discuss them with your legal office before acting. Okay, first thing, when a lien is received, you've got 5 business days to notify the prime contractor that the lien has been filed. In the letter, you need to notify the contractor that they've got 20 days to respond to the lien. OFCC sends out a notification to the owner agencies, that's you, of the project, letting them know that a lien has been filed on one of their projects. You will want to come up with an internal process to notify the appropriate people in your agency, such as your CFO, of the receipt of a lien. Another notification that needs to be issued is to your finance office when you're requesting a warrant to be deposited into your escrow account. You'll also want to send a cover letter to the escrow bank when the funds are deposited, as well as a letter to the bank to disperse the funds to the contractor once the lien has been released. If you'd like a template of the letters that OFCC issues, send me an email and I'll be happy to forward you copies of our letters. My contact information is here on this slide, and it's also at the end of the presentation. At some point, your finance office is going to need to receive instructions on the preparation of the warrant that's going to be deposited in your escrow account. Your finance office is going to need to know the amount of the warrant. They're going to need to set up a new address with shared services for the vendor. This address needs to be the name of the prime contractor, care of the bank, and the bank's mailing address. Your finance office also needs to be told to mark the voucher as return to agency. By doing this, rather than mailing the warrant directly to the bank, it will be returned to your agency. And once received, you can attach the cover letter and any other backup documentation that might be required by your bank. Our bank requires that we attach a copy of the lien and the escrow agreement. Once the warrant and all the required documentation are deposited, the designated person in your agency will record the deposit in OFCC. After the lien is resolved and you receive a lien release, the designated person in your agency will request that the bank disperse the escrowed amount plus interest earned to the contractor. I do this here at OFCC with a simple email and a copy of the lien release. On occasion, your prime contractor will bond off on a lien using their payment bond. When this happens, contact your legal department for instructions on the proper handling of the lien. Do you have any questions? I don't see any, so we'll move right on. Now we're going to talk about the processes involved in managing your liens and escrow accounts in OFCC. As we move through each of these slides, please keep in mind available on OFC's website for each of the processes. You're also going to find a link to those job aids at the end of this presentation. OFCC. OFCC is an excellent repository for all things that are related to your lien and escrow. It tracks all the steps, processes step by step, and it's a good place to store your documents. We recommend that you use Google Chrome or Foxfire as your browser to get the best user experience. In addition, as we go through these processes, you're going to notice a consistency and repetition in the different forms. Once you learn the fundamentals of one page on the form, you'll know how to use them all. When your agency has a lien filed on one of your projects, you want to create a lien record in OFCC. These next few steps are going to walk you through that process. First thing you're going to do is access OFCC using the URL shown here. Enter your username and password and click sign in. Don't forget to disable your pop-up blocker. After logging in, click the plus sign to open the search bar located in the upper right-hand corner and type in the project name or number. When the drop-down appears, click on the project to open up the record. Sorry, we're not moving forward. And there we go. It's probably going to go forward 3 screens now. Hopefully not. Okay, when you create the lien, you're going to enter a short title. We typically include the lien claimant's name in the lien title. Change the status of the lien to valid. Using the drop-down arrow, select the name of the contractor that the lien is being filed against. Window appears, select the appropriate contract and click select. Okay, now we're caught up. Next, you're going to enter the lien claimant's name, the date the lien was received by your agency, and the lien amount. Finally, click on the paperclip icon up at the top right-hand corner and attach a copy of the lien. Click submit. Okay, you've created your record. After the lien record has been created in OFCC, the notification letters that we mentioned earlier should be issued. Once that is done, you're going to want to go back into OFCC to record the sequence of these communications. Click on Logs, select the lien's business process, and select the appropriate lien to open up the record. Next, you're going to click on Edit to make the changes to the record. There are various edits you're going to want to make to the record throughout the life of the lien. You'll want to record when the notification letter went out to the contractor, when a dispute letter is received, and when a lien is released. But we'll go into releases in more detail later. Click as before, click on the paperclip icon and attach all necessary backup documentation. At this time, Christina Miller is going to take over the presentation and walk us through a pay request.
Hey, Julie.
Yes.
Really quickly, there was a question in the chat from Jennifer Strausser. Would you like me to read it to you?
I just, Yes, go ahead and read it to me.
Okay, just a question going back to the interest earned in the escrow account. The slide states earned interest is dispersed to the prime contractor. However, would the interest to go to whomever is awarded the funds? Would the subcontractor earn interest if the funds are due to them? For example, if the prime does not dispute the lien.
So all of the interest goes to the prime contractor, and I'm going to ask John or Matt to step in if you can add details to it. Because we're holding on to their funds in this escrow account, they are entitled to that interest that's earned.
Hey, this is Matt jumping in. So Jennifer, good question. For whatever reason, the money ultimately goes to the subcontractor because they didn't dispute the lien, that could be interest that would be awarded to that subcontractor. So that money would be paid out directly to the subcontractors. So the problem is with that is then, is that subcontractor entered into OAKS, et cetera? Do we have a vendor registration for them, et cetera? So the subcontractor would arguably be entitled to that interest, but typically it's not paid out directly to the subcontractors where it becomes problematic. So you won't have many issues where it's not disputed. And if it does, there's still going to be a dispute that's going to lead to a resolution, potentially outside of us issuing a check directly to a subcontractor, which I said is problematic. So I think that's a circular answer, which doesn't necessarily answer the question directly, but in most cases, you will not be sending that interest to the subcontractor, although arguably, legally, they would be entitled to it under the scenario you presented.
And Matt, I just want to, and Julie, this is John, just wanted to point out too, is that kind of as technology's advanced and the states move more electronically, it has made it more challenging to how we used to resolve liens previously in a paper world. Oftentimes the resolution, because you could not get the contractor and sub to agree, because they would have to sign lien release typically as well. It would be what we would call a check signing party, and it would be signed. You would bring everybody in the room. They'd sign the release to the lien, and then you would get a two-party check, which is made much more difficult under today's current. So that's a little off the question, but it just talks about some of the nuances, the challenges that come up in trying to resolve matters if a lot of liens come into play. Back to you now, Julie.
We're actually going to turn this over to Christina now.
Thanks, everybody. My name is Christina Miller, and I'm a project coordinator. And what I'm going to talk about is withholding the lien from the next pay request. After you've created your lien in OFCC, the next pay request that is submitted by the contractor is the one that you use to withhold the lien. When you do any pay request, the first step is always to check the lien business process just to make sure there are no liens on the contractor submitting the pay request. Typically, if you have a lien on a project, the project coordinator already is aware of the existing lien, but we always do check the lien business process just to be on the safe side. If there are liens listed for the contractor, what you want to do is total the amount of the lien in the withheld amount section here. You divide it up between this field, which is liens on labor and liens from material. One way, a little guide, is this field down here in the payment requested field. OFCC will already give you that information in these two fields. What you do is you enter the lien amount between these two fields, which effectively reduces the pay request by the amount of the lien. As you're doing that, these fields here can never go down to zero. OFCC will not let you move the pay request forward if these are in a negative number. Once you have withheld the lien amount from this pay request, you send a notification to your agency finance office requesting that a warrant be prepared payable to the prime contractor care of your escrow bank. And here you see suggested verbiage for that letter. Your next is to create the escrow account. You go to within the project logs, click escrow account, and then click the create button. The fields that you enter, the title, the status you change to pending, and the type is lien. Next, you want to select the contract that the lien pertains to. You click this icon, a new window pops up. You select the contract that's associated with the lien, and then you click select. That way you have your lien linked to your contract. The next thing you do is you want to look-see who your escrow agent is. You click this icon, a window pops up, you select your escrow agent, and you hit select. You want to go to the lien information section next. In the lien reference window, you click this icon again, a new window pops up, you click the appropriate lien, and you hit select. The next thing you'll do is you'll go to the transactions tab. Before we were in the general tab, now we're in the transaction. You'll click the add button. A new window pops up. The transaction type, you want to hit request. Enter your short description, enter the amount of the lien, enter the request date. If you have one lien, hit save. If you have multiple liens, as John referenced earlier, you'll hit save and add new. And what that does is it lets you add the next lien in the transaction section without having to go through the whole process with the general section all over again. Then lastly, you click the submit button. And I'll turn it over to Julie now. Thank you.
Thank you. Before we move on, I see another question. Ani, if the fees on the escrow account exceed the amount of the interest earned, does the state agency have to pay those fees from appropriated funds? I've never experienced that here at OFCC, but we probably would have a larger balance earning interest in our account than you would have. So I'm going to have to turn the question over to John and Matt, John or Matt Westerman. Can you answer that question? If fees exceed interest earned, how is the bank paid?
I mean, ultimately the state is, or the client would be responsible for the fees for their account. But you're right, we've not had to address it, and ultimately, hopefully, if you have one account, that's one of the reasons to have one account. For our agency or for other agencies to have their own account would be to hopefully the cumulative amount would keep the costs lower than the interest.
Hey, John and Julie, this is Barbara Tay Smith, Chief of Finance for OFCC. I'm going to go in on this and say that our escrow account is set up that the bank fee is based as a percentage of the interest earned. And so therefore, we have not run into that problem. The bank has requested that we change that process simply because they're not earning interest and their fees are so low, they don't feel that this is a good enough return. If that were to happen, yes, we would have to pay the fees out of our appropriation authority, but at the same time, we would record those against each of the individual accounts we have within our escrow account, so that when we did pay out money, it would cover the fee. So in essence, it would be a charge against the individual accounts, but it does reduce your appropriation authority by needing to pay that fee. So that's why it's really critical to set up the account the right way.
Yeah, and Barb, historically, that was never a problem because interest rates were never as low as they have been the last 6 to 8 years. And so they're used to, in a lot of areas, especially on school projects, local banks used to also do those services for free to school districts or some of our school district clients. But we've seen that shift over the past 6 to 8 years as well. So there's been a lot more fee-based banking, I guess I would say, that's added additional challenges to us.
Hey, John, this is Stacy Thomas. Just to chime in on that, when I've had the issue before, long time ago, where a district did an escrow agreement and it was like $2,500 and we earned maybe $500 of interest. And so the contractor, I understand that this is for liens, but it was an escrow account for retainage and they were really upset. So I have told my districts to always make sure that it's based on a percentage basis and not a whole dollar amount for the escrow account, because we have had that happen where it was extreme how much the charge was for the escrow account compared to what interest. So I would just do, like you said, always tell them to make sure that they're with a bank that will do it on a percentage basis rather than a set dollar amount. And if they won't, then go to a different bank.
And this all kind of evidences another point, is that if it's not a project that has, that's gone crazy with liens, we believe the due and payable, one of the reasons the due and payable is so important is that we don't need to put things into escrow as fast, until that pay application comes through. And hopefully that any liens, again, will get resolved. And that's, I know we can't count on that every time, but that's the kind of the ultimate goal, is that hopefully that the principal and the claimant will resolve their issues, and we don't have to play the roles of pushing the money into escrow.
This is Carrie Yost with ODOT. I was wondering if I could chime in. One of the things that we're doing or looking at doing at ODOT, and our finance people can add to this, but we were doing separate accounts for every vendor. And we were wondering, is it possible for us to take the fee, if we had a flat fee, and actually include it in our bid documents so that it's part of the project for the setting up the account?
I guess I've never hadn't thought about it. It seems like a novel way to address it. Matt?
Yeah, I'm curious to think that through as to whether you could do it as a flat fee. I don't think it's ever meant to be a fee. And following up on what Barb said, I don't think it's ever meant to be a fee that would actually reduce, for example, the lien amount. Or so if you set it up front, is that a fee? I'd have to look into that, Carrie, and get back to you as to whether that would be possible. I mean, I think the point is that the statute allows you to commingle the escrow accounts, so that'll address a lot of these issues. If you have a lot of accounts, including potentially, your retainage being in there, then you'll have a fairly sufficient amount of money earning interest, which should satisfy the fees related to a single escrow agreement if you can get it set up that way for a project, rather than having multiple escrow agreements.
This is Alana Haberman with Finance Office at ODOT. Because our escrow account for OFCC projects is new and it doesn't have a lot of deposits into it, we did have to work out a fee structure with the bank because there was not enough, as stated before, enough interest earned to account for the fees for the bank to maintain the account for us. So we were going to deduct that from the lien amount when we paid it out. So Carrie's idea of putting it in advance would give them advance notice of understanding that it would happen.
And this is John. Maybe points to something we should all consider as we go through budget seasons and central language issues. Is an escrow account a thing of the past, perhaps? I mean, maybe we ought to just set it up to say that, you know, we have an interest-bearing account, I mean, which would still have a fee, but we have to think about, I understand the need for the escrow account. It makes it easier about how the money's released. But we've seen other kind of public owners try to modify contracts to include just, you know, interest-bearing savings accounts and other things. And we might have more trouble as the state doing some of that, but we might have to start to look at the statutory constraints and see, does the escrow, because of the fees and issues, start to cause more issues and headaches than any benefit? It's not like any contractor is going to really benefit from any interest that's in there because of the fees from these discussions. There's going to be relatively little interest in today's current time period. So, but thanks for sharing all the information.
Sure.
Okay. Jumping back to the presentation, Matt Weber, I'll either need control or you can move the slides forward, whichever you prefer. So where we left off was pay request has just been approved for payment, and now it's time to put your escrow amount, put the amount into escrow. And you'll want to record that transaction in OFCC. To do this, you're going to log into CI and open your project the way we went through before. Select logs on the left-hand side of your screen, and then select the escrow accounts business process and select the appropriate lien. To begin working on the record, click the edit button. Change the status to open. On the status field, change that to open. Enter the warrant number that you've received and the warrant amount. Next slide. Next, click on your Transactions tab up at the top and open the appropriate transaction. Change the transaction type to deposit. Enter the date that you send the check to the bank and click Save. You're going to want to return to the General tab and attach a copy of the warrant and any other documentation you might desire and click Submit. At some point, you're going to receive a release on the lien. Once all the parties are in agreement and before payment can be released to the prime contractor by your bank, a lien release must be received. This release may only be a partial release, meaning it's not the full amount of the lien. If this occurs, the amounts entered on the following slides should only be for the partial amount received, partial lien release received. But typically, you're going to receive a full release, meaning the entire amount can be released. So once again, you follow the steps to open up the lien record. Go to Logs, Liens, and select the appropriate lien. Next slide. Click on Edit to begin working on the record. And click on the Releases tab at the top and click Add. You're going to want to enter the release details, such as the date you received the release, a short description, and an amount. Remember that if you received only a partial release, you will only release that amount. And finally, click Save. Go back to the General tab. And when the lien is fully released and the lien balance is 0, change the status of the lien record to released. Do not change the status until the lien is fully released. Enter the release date, click Save and Submit. This is important. You'll notice in red that once the status is marked released, clicking Submit will complete the record. At that point, you're only going to be able to view the record. You won't be able to perform any editing. And next slide. So now that your lien has been released, you're going to want to update your escrow business process accordingly. So go to the next slide. Click on Logs, select the escrow accounts business process, and select the escrow account. Click Edit. This opens up the record for editing. You're going to click on the Transactions tab, open the transaction by clicking on it, change the transaction type to Release, and enter the transaction date. Click Save. Going to want to return to the General tab and change the status to Closed. Again, as always, add any backup documentation by clicking on the paperclip icon. Just like on the lien record, once you change the status to Closed, you will no longer be able to edit the record. Go to the next slide. At this point, you're going to send a letter to your escrow bank requesting that they disperse the escrowed amounts plus any interest to the prime contractor. And that is it. If you have any questions on the OFCC process, please feel free to contact our OFCC support desk. At this time, I'm going to turn the presentation back over to John Walden or Matt Westerman for our closing remarks. Thank you.
Yeah. So this is John again. We want to thank you for letting us share a little bit about the lien process. We understand you might not have a lot of liens, but if you go through it the first time or have to go through it when there's a lot of liens, there could be a lot of questions that come up. And we're always here to help if that's the case. Whether it be through something in CI or whether you want to talk to Matt or I about how to address certain issues that come up. We also work with the Attorney General's office if there are actual claims that or lawsuits that arise out of this. The AG's office has been very good about making sure they've been filed in the appropriate location. And we push really hard to try to get them at that point bonded off, or if we have any contract balance left that the state is not trying to claim first, we can always do an interpleader and just we would put that into an account for the court to address, because most of the time we don't, other than holding the money, we don't want to, we're not really involved in those disputes about whether someone was paid or not, other than we do want contractors to get paid for work they perform and perform well. We're open for any questions now. If you have any further questions, liens are not a really exciting topic to talk about, but we wanted to at least give you a sense of how we at OFCC work as a team to address it when it gets to be more than just a single lien on a project. And it really starts to, as we dealt with on a project for a different agency, Christina, I'm not certain how many liens we had. Matt might have a better number as we resolved it, but for a while there, we were getting, felt like a lien a day over a period. And we probably had several $100,000 of liens on this project. And it was, as we talked about, the case where a contractor was failing. They failed on multiple projects, public projects throughout the state. And we really, we had to work together to try to resolve these, to try to account for them properly in CI and addressing them through the contract balance.
Yeah, John, on that project, we actually had over $1.2 million in liens that were filed based on a total project cost of a little over $5 million. So close to 25% of the liens were funded at one point during that project.
Yeah. Julie Strasser, I saw you had your hand up. Do you have a question, another question?
Yeah, I do. Thank you. This is for Julie. I was wondering, I'm with ODOT. ODOT has had lien accounts for many, many years, and we've always gone through OFCC kind of as just a middleman or a third party to deposit our funds into escrow. We've since, as Alana and Carrie alluded to, we've since established our own lien account with Huntington that we can go directly through. And we told you we're, creating separate accounts for each lien. But my question is, when OFCC was handling our deposits, few months ago, all the way through back in the day, were they doing this part through OFCC, creating the lien record and all that? Because that's something that ODOT has never done. I just wonder how that factors in, or is that because we have our own account now that we'll have to be, starting to do this OFCC part? Just something I'm not familiar with.
Yes, we did record all of your deposits in OFCC, but not in a place where you would see them. We had a special escrow account in CI for that purpose.
Okay. All right, that makes sense. So that was something that you're kind of doing for us. We may not have even been aware of it, but now with our own accounts, we'll be having to take over that.
Yes, that is correct.
All right, thank you.
You're welcome.
Thank you for the question. All right. If there's no other questions, we thank you for your time and give you a little bit of time back. It went a little faster than I think we anticipated. We hope we at least able to point out something. We know that people in different areas, some parts are not as relevant, so we appreciate that. If you have other areas that you would like that you have questions about, or we could help to try to put something together, please let us know, and we'll try to work with you on different topics and discussions that might help on any local administration of your projects. At this point, I think we'll wrap up. Thank you very much, everyone, and thanks to the team for putting it together.